All right, students, for our Dewey-ing history debate, today we're going to talk about something called civil rights. That's probably a phrase that you have heard dozens and dozens of times in your educational career, but I wonder how many times they've actually had it defined. So before we get started, you're going to define what civil rights are. The dictionary defines civil rights as the rights that every person should have regardless of his or her sex, race, or religion. Put this into your own words on the worksheet. Our question-focused document was a cartoon drawn by Thomas Nast in 1875 titled "To Thine Own Self Be True." That was a quote from Shakespeare, but what's happening in this cartoon? I'll let you know here just because you might not understand this. This bracelet this woman is wearing says Columbia. Some people refer to the United States in an effeminate form as Columbia. So what is Columbia handing to this person? And who is this person? Try and identify how what's going on in this document may be related to a present problem that America is facing. And then generate your own question. When you look at this cartoon, what do you wonder? What makes you curious? As we learned from John Dewey, the starting point of history is always some present situation with its problems. We're going to learn about a recent debate happening related to the Fair Housing Act in the Trump administration. In order to do that, we're going to go to this article, and you're going to listen to this article. I'll go ahead and tell you that right here, we're looking for disparate impact. That means that to prove discrimination in a lawsuit, plaintiffs don't have to prove, for example, that a bank employee is refusing to make loans to people of color. That describes discrimination as we know it, just blatant racism, more or less. They're discriminating against people because of who those people are. What disparate impact allows is that they only have to show that a company has a business practice that, on its face, may not be purposefully discriminate, but has a discriminatory effect. So if a bank or a business is doing something that isn't intended to discriminate, it's not intended to treat people of color differently, but it just happens to treat them differently, then disparate impact would help create a lawsuit against that. You're going to look for why people support this. Nikita Bailey in the article will tell you that. And then Roger Clegg will tell you why some people oppose that solution. Why do some people oppose disparate impact? After you've listened to both sides of the debate, explain which side you land on. Now, to reflect on the disparate impact policy debate, we're going to do a case study over something called the Civil Rights Bill, which was House Resolution 796. Go to the web page so we can learn about House Resolution 796. This is the Civil Rights Bill. The Civil Rights Bill said government should recognize the equality of all men before the law. It is their duty to create equal justice for all, of whatever nativity, race, color, or persuasion, religious or political. It is the goal of legislation to make these great fundamental principles into law. Therefore, so it's a pretty strong introduction to the rest of the policy. They're just laying out that it's the government's job to make sure all men are treated equal. The policy states, all persons in the United States shall have full and equal enjoyment of the accommodations, advantages, facilities, and privileges of inns, theaters, and other public places, except by laws that apply to citizens of every race and color, regardless of any previous condition of servitude. This wording obviously not intended for teenagers in 2020, so we need to discuss what they mean there. All persons in the United States shall have full and equal enjoyment. So all people should be able to use these places: inns, theaters, other public places. Public places would be places of business that the public would go to for different services. So what is this saying? Section 2. Any person who denies or helps to deny equal access to any citizen shall pay $500 to the person offended. They will be guilty of a misdemeanor and shall be fined not less than 500 nor more than 1,000, or shall be imprisoned not less than 30 days nor more than 1 year. So if you are the owner of a hotel or a theater and you don't let somebody use your business, if you discriminate against somebody because of a racist reason, you're going to first have to pay $500 to the person you discriminated against. And then you're also going to be fined $500 or $1,000. So if you tell somebody just because of the color of their skin they can't come into your hotel or eat at your restaurant, you're going to owe some money. Section 3. The courts of the United States shall have knowledge of all crimes and offenses against and violations of this act. Section 4. No citizen qualified for service as a juror in any court of the United States or of any state on account of race, color, or previous condition of servitude shall be excluded from the right to serve on a jury. Denying one their right is a misdemeanor with a fine up to $5,000. What's important about Section 4 happens to be related to the Bill of Rights, the idea that you're supposed to be guaranteed a fair trial of your peers. If a state or locality is not allowing people of color to serve on juries, leading to all white juries, are those juries going to give people of color a fair trial? No, would be the answer. So you should be able to tell me what House Resolution 796 would do. Just fill in the blanks. House Resolution 796 would make it illegal for who to do what? Now we need to study the historical context to understand what led to this. As you all know from our other assignments, America has a little bit of an issue with slavery. First slaves arriving in 1619, and following that, up until 1865, slavery is legal in the United States. While there were people through organizations like the Underground Railroad and the abolitionist movement fighting against slavery, by and large, the United States as a whole allowed it to happen. That included the 1857 Supreme Court decision Dred Scott, which denied citizenship rights to African Americans. In 1860, Abraham Lincoln is elected president, and 11 southern states secede from the Union to form the Confederacy. That becomes the Civil War. 1863, Lincoln issues his Emancipation Proclamation, freeing slaves in the Confederacy. After that, Robert E. Lee, Confederate general, surrenders. Lincoln is assassinated. Andrew Johnson becomes president. 13th Amendment abolishes slavery. Very, very important things to happen related to the status of the freemen. But once the former enslaved people are set free, very rapidly in the southern states, they start developing these slavery era codes making requirements for blacks to live, work, or vote. In 1866, Congress passed the first Civil Rights Act. This act made black codes illegal. It said all persons born in the United States are hereby declared to be citizens of the United States and have full and equal benefit of all laws and proceedings for the security of person and property. It's easy for us to understand that the South, which had supported slavery for so many years, was not going to just all of a sudden change how they treat these people. So the government was having to take steps to try and protect the rights of these people, including the 14th Amendment, which gave them citizenship, the 15th Amendment, which we learned about as giving African Americans the right to vote. We get to 1870, and a senator named Charles Sumner introduced a bill called Supplementary to an Act entitled An Act to Protect All Persons in the United States in Their Civil Rights. Sumner was the one who really pushed for this civil rights bill that was going to fight discrimination in schools, churches, cemeteries, and other public places, although it's never voted on. In 1870 and 1871, we have enforcement acts that were created to fight the KKK. 1872, Sumner introduces his bill again. Congress still does nothing. 1873, the Supreme Court's ruling in the slaughterhouse cases says that there's a difference between federal and states' rights. The 14th Amendment only protected federal civil rights. States did not have to protect all civil rights. This Supreme Court case basically says the rights that people are guaranteed by the federal government don't have to be protected by a state government. In 1874, Charles Sumner dies. In 1875, Benjamin F. Butler from Massachusetts introduces House Resolution 796. So we are going to talk about documents from the vote and the debate over the Civil Rights Bill. In Section 1, we're operating under the guiding question of why do people think the government has a responsibility to promote equity? Equity meaning equality. Why do some people think the government should be trying to make sure people are treated equally? We're going to go down to a speech by Robert Elliott. So as we read this, make sure you highlight important text, but before that we need to talk about the sourcing. Robert Elliott here was a African American Republican congressman from South Carolina. He was born in England, but after moving to the United States in 1867, he became involved in politics. After the end of the Civil War, and after the right to vote is protected for some African Americans, those African Americans go to the polls and vote for men like themselves. This results in a number of African Americans going to Congress. Robert B. Elliott is one of those men. So we should know that when we're talking about who he was. And how might that lead to him having a bias? A bias is someone has a tendency to favor one side over the other. Not to be making stereotypes, but why would Robert B. Elliott's background lead to him favoring one side of a debate over civil rights? Let's read his speech and see if he gives us any good reasons why the United States should work to promote equity. Congressman Elliott said, "I regret it is necessary to convince Congress to support a bill that is trying to give equal rights and equal public privileges to all American citizens. I support this act because it is right. It represents justice and should be supported out of gratitude for the Negroes who defended the Union in the war. Mr. Stevens tells Congress they have no constitutional power to pass this law, saying it goes against the rights of states. I disagree. The Constitution should always favor human rights. The 13th, 14th, and 15th Amendments give Congress the power to protect the citizen in his civil and political rights. Their purpose is to secure equality before the law of all citizens of the United States. Under the 14th Amendment, no state shall deny to any person within its jurisdiction the equal protection of the laws. It is under this idea the Civil Rights Act was created. American citizenship carries with it civil and political rights. If the states do not follow this law, then Congress has power to enforce the Constitution by appropriate laws. That is what this bill now wants to do. It does not seek to create new rights, but simply to prevent and forbid inequality and discrimination on account of race, color, or previous condition of servitude. Never was there a bill more completely within the constitutional power of Congress. I have the honor to represent the race which pleads for justice at your hands today. The war settled our political status. This bill will determine the civil status, not only of the Negro, but of any citizens who may feel themselves discriminated against. It will form the capstone of that temple of liberty. We are at last politically free. The last vesture only is needed: civil rights. I want you to imagine having been sitting there listening to this speech. This is 1874, only 9 years after slavery has been made illegal. And this African American man stands before Congress and delivers this speech. What reasons did he give for why the United States should support a civil rights law making discrimination illegal? He talked a number of times about equal rights, equal privileges, and citizenship. In this line, he made a comment about how we should support it out of gratitude for the Negroes who defended the Union in the war. African Americans joined by the thousands to fight in the Union to defend the nation which had allowed them to be enslaved for a century. It's amazing that they were willing to do that, considering what had just been happening. So he's saying here, we owe it to them. He discusses in this paragraph the goal of the Constitution, especially the Constitution should always favor human rights. He seems to think in this paragraph that it's the role of the government to make sure we're looking out for people's There's a number of things in here which I think are very good reasons why the government should work to promote equity. Try and focus on one of them. Highlight it, turn it to red, explain what the quote means, and then explain how that evidence is related to today's debate over disparate impact, which is that housing law that makes it illegal for businesses to do something that has a discriminatory effect. For our visual argument, we're going to look at this cartoon from Thomas Nast called The Jubilee, 1875. Know that Thomas Nast, a cartoonist, is going to have characters that do play on racial stereotypes. So this cartoon is reasonably offensive. But let's try and see what we're learning from the cartoon. You need to figure out, who is this man here? He's holding a key. Does anyone know who St. Peter is? St. Peter is the one who is the gatekeeper to heaven. He decides who gets into heaven. This man right here is a freeman. What's he holding in his right hand? What does it say here? What is the freeman telling St. Peter? That St. Peter can't discriminate? What's the idea of this cartoon? Freeman says, "Hi, Massa Peter, you can't object to open the gates to me now." Thomas Nast is saying in this, the Civil Rights Bill is going to prevent even the highest of powers from being able to discriminate. How would that idea be related to today's debate? If God himself should not be able to discriminate, should the owner of a hotel or the owner of a bank be able to discriminate? I told you earlier about Reconstruction and how Robert B. Elliott was one of the group of men, African American men, who were the first African Americans in Congress. This portrait by Currier and Ives shows that group. It was a very significant time, Reconstruction, that the federal government was protecting the rights of these people to vote, and they chose to vote for people like themselves. So in the 1870s, we had a number of African American representatives in Congress. We're now going to go to section 2 and try and find out why some people oppose the government promoting equity. We're going to read a speech by Alexander Stephens, a Democrat from Georgia. But before we do that, we need to talk about his bias. Before Stephens gave this speech, he had been the vice president of the Confederacy, and he is most known for a speech that's known as the Cornerstone Speech. Just want to let you know what we're about to read is quite terrible. In that speech, he said, "Our new government is founded upon exactly the opposite idea. Its foundations are laid, its cornerstone rests upon the great truth that the Negro is not equal to the white man, that slavery, subordination to the superior race is his natural and normal condition." This man, the vice president of the Confederate States of America, gave this as the reason for why they were creating a new country. And I'm sure you all will agree that it's quite racist. So Congressman Alexander Stephens used to be the vice president of what? And how could that lead to him being biased? Based on that little quote we just read, what's his bias going to be in relation to a civil rights bill? Right, so we're clearly establishing that Alexander Stephens has some very racist background. In this speech, he may give you reasons against civil rights that are racist, but we need to try and focus on seeing if there are any things that are more logical than racism, because we don't want to justify that. In his speech, he said, "I am not against this act because I am against justice for every human. The goal of all governments should be the protection of rights. The struggle of humanity has been trying to balance government power and people's rights. While I do not believe in a racial equality, I do believe all men are created equal. This great truth was first said by Thomas Jefferson. In my opinion, he was not saying men are created equal, but meant all men have a right to equality before the law. This is the right of all men, whether white, red, brown, or black." So we already know how he feels about the different races. He obviously has feelings against people of color. So he doesn't think they should be treated equally in society, but he does say they should be treated equally before. So who are the only people who have an obligation to treat them equally? The law is the government, correct? Let's see if he gives us any better reasons to oppose it. "I am opposed to this act or anyone like it because it gives Congress more power. Where does the Constitution say we have the power to make this law? The power under which it is claimed is derived from the 14th Amendment. Neither of these amendments give any rights at all to citizens of the United States. They only forbid the states from discriminating in their laws against the colored race. Whatever rights they grant to other citizens shall not be denied to the colored race as a class. This is the whole of the matter. The question is, how can Congress enforce a prohibition of the exercise of these powers by a state? How is just this line a reason why we should not support a civil rights bill at that time? The idea of giving Congress more power? Do any of you like the idea of increasing the powers of the government? If you distrust the government, you probably don't want to give them more powers. He goes on to say, interference by the federal government would be against the very genius of our government. If there is one truth which stands out prominently above all others in the history of these states, it is that the principle of American constitutional liberty is the absolute unrestricted right of state self-government. I oppose this act because even if Congress did have the power to pass the law, I think it would be better to let the states solve the issue. You've maybe heard that some people say the Civil War was about something called states' rights. He's arguing in this paragraph that the federal government needs to basically stay out of states' business. States should be the ones in charge of what happens in their state. After you've highlighted text, summarize that, and tell me how it's related to today's debate over disparate impact. Our second piece of evidence is another Thomas Nast cartoon, this one called The Civil Rights ? Waiting for a $500 kick. There it is. All right. Let's try and figure out what is happening in this cartoon. Again, Thomas Nast, 1870s. There are some racially insensitive characters here. What's the freeman holding in his hand? Where is he? What's this say on the window? If they're in a hotel, who is this guy? What is he holding out to the freeman? The title of the cartoon, Waiting for a $500 Kick. Think back to the Civil Rights Bill. It said if you got discriminated against, the owner of the business that discriminated against you would owe you $500. What does this freeman seem to be hoping happens to him? The manager is trying to get him to book a room, but he doesn't seem to be interested in getting that room. So what is it that some people may think here? The main idea of this image is they're worried that the Civil Rights Bill could be, what's this guy trying to do? Now, to connect that to today's debate, if you think back to the article, some people who were opposed to it believe that the lawsuits, I believe the article used the word frivolous, unfair lawsuits. The idea that people will abuse disparate impact and create lawsuits which are not fair to the companies getting sued. Does that look like what's happening in this cartoon? All right, so let's find out what happened to House Resolution 796. We should celebrate because Congress did the right thing in 1875 and decided that they should make it illegal for businesses to discriminate against somebody for racist reasons. It was passed and became known as the Civil Rights Act of 1875. It was signed into law by President Grant on March 1st. It made it illegal to discriminate in transportation, hotels, theaters. It said if you got discriminated against, you got to sue. So imagine that you were discriminated against by a business and laws said that if you sued, you get $500 from that person. 1875, we know racism was an issue, so it's reasonable for us to assume that businesses were going to discriminate. And since those businesses were discriminating, it's reasonable for us to also assume that people are going to sue them because they felt offended by being discriminated and they want that $500. What happens is that there's a number of cases that are created out of this. United States versus Stanley, United States versus Ryan, United States versus Nichols, United States versus Singleton, and Robinson versus Memphis and Charleston Railroad. All of these are grouped together in the civil rights cases in 1883. So you need to tell me what they decided to do. Did they make it a law? Why did they decide to make it a law? And then what were the consequences? After they made the Civil Rights Act of 1875, what happened? So now we're going to start the second part. We're going to talk about the Civil Rights Supreme Court case that happened as a result of the Civil Rights Act of 1875. We're going to need to open this link to find out about the civil rights cases. Still trying to find out what the government goal should be related to civil rights policies. You already know the historical context because that's what we just discussed. We need to find out, why do people believe the United States government does not have a role in enforcing civil rights? We're going to read the majority opinion of Chief Justice Joseph P. Bradley. He represented the majority. He's the one explaining why the Supreme Court decides to overturn the Civil Rights Act. This Supreme Court decides whether or not a law, well, not whether or not it was broken or not like lower courts. They decide whether or not the law that was broken was a law that was constitutional, meaning should it have even become a law? We need to find out why he thinks the Civil Rights Act should not have become a law. As we read, change text that you really see as leading you to understand why some people oppose the United States acting in a role that is enforcing civil rights. Chief Justice Bradley said, "Invasion of individual rights is not the goal of the 14th Amendment. It makes illegal all state laws and actions, which hurt the rights of citizens of the United States, or which injures them in life, liberty, or property without due process of law, or denies them equal protection of the laws." The 14th Amendment, he's saying, is just making illegal state actions, not private. It does not give Congress the power to make laws that should be made by the states. It does not authorize Congress to create laws for cities controlling private rights. It would be running the slavery argument into the ground to make it apply to every act of discrimination a person makes when he decides which guests he will entertain, who he will take into his car or admit to his concert or theater or do business with. Innkeepers and railroads, by the laws of all the states, are already required to give good accommodations to all unobjectable persons who pay for them. In these paragraphs, he says that the 14th Amendment is supposed to be able to stop states from discriminating, but it doesn't do anything to prevent private individuals from discriminating. Private individuals would be business owners. When a man has emerged from slavery, his rights as a citizen or a man are to be protected just the same as other men's rights are protected. There were thousands of free colored people in this country before the abolition of slavery, enjoying all the rights of life, liberty, and property, the same as white citizens. Yet no one at that time thought it was any invasion of their rights as freemen because they were not admitted to all the privileges enjoyed by white citizens. Discrimination based on color were not seen as part of slavery. What he's saying here, discrimination based on color were not seen as part of slavery. And what he said up here, it would be running the slavery argument into the ground. Many people supported the Civil Rights Act because of America's terrible history with slavery. They said that slavery is the reason these people are treated poorly, therefore slavery is the reason we need to do these things. But Joseph Bradley here seems to think there's a difference between slavery and discrimination. He doesn't see them as being the same thing. So while he's opposed to slavery and thinks the government should be fighting against slavery, he doesn't think that discrimination is the same thing as slavery. So ask yourself how this statement by a man in 1883 saying that slavery is no longer an excuse, how could that be related to people debating civil rights policy decisions today or disparate impact policy today? Now we need to read the other side. Justice John Marshall Harlan, he wrote what's known as the dissenting opinion. When you disagree, you dissent. He's going to explain to you why the government does have a role in enforcing civil rights. Justice Harlan said, "The purpose of the Act of Congress of 1875 was to prevent race discrimination. It does not define how inns, public conveyances, and places of public amusement must be run, but only outlaws discrimination based on account of race, color, or previous condition of servitude. Some argue Congress did not have the power, even under the 13th or 14th Amendments, to create the Civil Rights Act of 1875. I argue that since slavery was the main reason the 13th Amendment was created, and since that institution rested wholly upon the inferiority as a race of those held in bondage, Congress, therefore, under its power to enforce that amendment, may create laws to protect people against discrimination because of their race, of any rights enjoyed by other freemen in the same state. The right of a colored person to use a public highway, like freemen of other races, is as fundamental a right as any other civil freedom. This discrimination is based on the same foundation as slavery. The only way it will last is if, in this land of liberty, a class is allowed to be discriminated against. The purpose of congressional legislation has been to enable the black race to take only the rank of a citizen. No state or corporation can discriminate against freemen or citizens in their civil rights because of their race. The rights Congress, by the Act of 1875, work to protect our legal, not social rights." This idea right here should be focused on. As we heard from Alexander Stevens' speech earlier, slavery was based on a racist idea. Is discrimination based on a racist idea? Yes, absolutely. So if the racist idea that was the foundation of slavery is the racist idea that's the foundation of that discrimination, if the government is supposed to be fighting against racism because it led to slavery, should the government be fighting against discrimination because it's tied to slavery in that way? How could this be related to something that's being said today? Is somebody being discriminated against by a bank? Is that the same thing as slavery? No. But is it based on the same racist ideas as slavery? If you would agree so, then that would be why you would argue we should think about this when we're debating civil rights policy decisions. All right, so you know that the Supreme Court overturned the Civil Rights Act. That means that it became legal for those places to discriminate against people. They no longer had to pay $500 or pay a fine. So a theater could now legally discriminate. What do you think are going to be the consequences of those decisions? Are they going to not discriminate, even though it's legal? Or are they going to discriminate? And if they are discriminating, are things going to get better or worse? Let's make a quick comparison and contrast the two debates. What is similar between the two policy debates? They are government actions trying to prevent, what's that word that starts with a D? Discrimination? What kind of discrimination were they trying to prevent in the past? It was discrimination that was blatant and racist, just outright upfront. Hotel owner saying, you can't stay here because of the color of your skin. That kind of discrimination is still illegal today, but think about what disparate impact said. Is it racism that's blatant, it's out front? What did the article say about the type of racism or discrimination that's affected by disparate impact? Okay, now it's time to create your policy advice. So consider all that we just learned about civil rights, from the disparate impact to the historic debate over the government's involvement in fighting for civil rights. You need to tell me whether or not policymakers should support or oppose the Trump administration's decision to end disparate impact. If you think that the government should play an active role in fighting against all forms of discrimination, you're going to oppose their decision because they're getting rid of that program, as we learned in the article. If you are going to support Trump getting rid of it, whose arguments are you going to use from the historic debate? You can choose to either use the documents of the Supreme Court case, or you can use the documents above in the case study from the Civil Rights Act. I suggest you use these above. Which section is going to be useful in proving which one? Section 1 thinks we, the government, have a responsibility to promote equity. Section 2 thinks we do not. Consider which one of those sides is going to support which argument. So now you should create your policy advice. Don't forget to grade yourself on the rubric. And if you feel like you can, give you a shot at the extra credit. It may be worth it. If you have any questions, please let me know.